gentlemen, very distinguished members of the audience, welcome to the first big national debate we have here today on a very important subject of legislature versus the judiciary. The context is pretty simple. The decision of the Supreme Court of India on the 16th of October 2015 to strike down the National Judicial Appointments Commission Act has led to an unprecedented standoff between politicians and judges, between the legislature and the executive on one side and active and former members of the judiciary on the other. And nobody can really question whether this debate is happening or not. The standoff has started. It is a reality today. I'm very proud that we have with us today four extremely distinguished debaters who between them are truly a treasure trove of experience, of wisdom, of insight. And at the same time, these four gentlemen who will be debating today represent the two strongest poles of this debate. And I am truly honored that they have agreed to come before this live audience today and before all of us in an open forum which is going to be televised over this weekend across the entire world to millions who will be watching. And I'm also very honored that I have with me to my left and right two leading opinion makers and thinkers and journalists, Swapan Dasgupta and Dilip Padgaonkar, both very forthright in their views and both never shy to take a contrarian position. Swapanda and Mr. Padgaonkar, welcome. What are you looking forward to in the debate today? Mr. Padgaonkar, just one line from you to start with.
I'm looking forward to getting to know the many shades of this debate. It's a complex debate, and I think to try and reduce it to a kind of a fight between heroes and villains, I think would denature the debate. I believe also, secondly, that with some degree of understanding of these complexities, maybe at the end of the debate, some kind of consensus might emerge to take things forward.
Swapanda.
No, I'm not looking for a consensus. Basically, I'm looking to demystify the legal jargon and somehow get a measure of clarity as to what and why this judgment has a bearing on India's constitution and on India's politics.
Thank you, Swapanda. Thank you, Mr. Padgaonkar. So, as I introduce each of the speakers today, please put your hands together for them because they've taken the trouble of coming today and agreeing to face off with each of them. So on the one side of the divide today is one of the most, if not the most vocal proponent of the National Judicial Appointments Commission, the strongest critic of the Supreme Court judgment, and without doubt one of the most distinguished members of the bar, to say that Mr. Jaitley's articulation of the Supreme Court judgment as quote-unquote the controversial phrase tyranny of the unelected has ruffled a few feathers would be an understatement. So representing the legislature's point of view, our first speaker, India's Minister for Finance, Corporate Affairs and Information and Broadcasting, Mr. Arun Jaitley, please. And joining Mr. Jaitley on that side, a person I have respected over many decades and still do increasingly every day, Mr. Soli Sorabji, former Attorney General. He has witnessed from very close quarters the evolution of India's judicial system over the years. He feels that the system of judges, solely appointing judges, is a bad idea. Mr. Sorabji, thank you very much. And facing them off on the other side today, defending the judgment, Justice R.M. Lodha, former Chief Justice of India, who has delivered some landmark judgments in our judicial history, including the cancellation of coal block allocations. In an article recently, he delivered a point-by-point rebuttal, some of you may have read it, to Mr. Arun Jaitley's arguments against the judgment, claiming it is the judiciary's responsibility to protect the constitution, even when it is under threat, in his own words, from quote-unquote, a direct response it was, I thought, to Mr. Jaitley, the will of the people. And with him today, Mr. Lodha, Justice Lodha, thank you very much for coming. Thank you. Looking forward very much. And with him today is Rajiv Dhawan, Senior Advocate of the Supreme Court of India. Very outspoken man. I hope he will not pull his punches today. He's an amicus in this case, a leading authority on the Constitution and a very strong critic of the National Judicial Appointments Commission. He refers to it as, quote, fragile and fraught with mischief. I am so privileged today, ladies and gentlemen, to be moderating this discussion in the presence of such eminent people. Before I begin, can I just introduce a broad format for today's discussion? First, we'll have opening remarks, 2.5 to 3 minutes from each speaker. Before we came in today, we decided the order of the speakers. I will follow that. In opening remarks, we will expect the speakers on both sides to be responding to each other with rebuts to the points made by the previous speaker. So more than your individual speeches, we want to see you rebutting with each other and countering each other's points. Then we will go to the substantive part of this debate, which we will divide into 4 key points. Each side will take a question followed by a debate involving both set of participants. I have divided this into 4 themes, and I seek the indulgence of the audience, including the very senior jurists in the audience, if I have not got it right. But I have discussed it with the panelists. The 4 points will be: A, does the Supreme Court verdict damage parliamentary sovereignty? B, was there government trying to compromise the idea of judicial independence and create an imbalance in our system? 3, and this will be important for Justice Lodha and Rajiv Dhawan, was there a slow usurping of power by the Supreme Court of India over the decades in defiance of what the founding fathers of the Constitution wanted, to make it itself all powerful? And finally, what best will serve the interests of the people of India? So these are my 4 basic subjects, about 15-20 minutes on each. 1 question on each, and then followed by rebuts. Then we'll have a free debate in which both can demolish each other's side. I will not have a show of hands in this debate. This debate is live across the social media. Just like the 9 p.m. TV shows that Mr. Jaitley refers to in his Facebook post, please allow the other side to complete their point before you intervene. Should we start the debate, ladies and gentlemen? And to the audience, feel involved. This is your debate. You are here live, and you are free to applaud or cheer anyone without distracting them. So I'd now like to begin the debate with Mr. Arun Jaitley opening the debate. The subject is clear before you. Mr. Jaitley, take the floor.
But first of all, 2 basic preliminary points, Arnab. The issue is not legislature versus the judiciary. The legislature legislates. What is best for India, the legislature decides. The judiciary unquestionably has the power of judicial review. Either the executive or the judiciary or the legislature cross the line, the judiciary can step in. The second, there is absolutely no debate on the issue: is independence of judiciary a part of the basic structure? Unquestionably it is. Does India need an independent judiciary? It does. Does it need a powerful judiciary? It does. But I think what's more important is, and that's now more important than independence of judiciary, is the credibility of the institution. The credibility of the institution involves independence, it involves scholarship, it involves fairness, and it also involves respecting other institutions. Now let us look at what the Constitution says. When this particular provision of the Constitution was moved, Dr. Ambedkar itself said, must the President, that is the Council of Ministers, alone have the power to appoint judges? He said, no, that's not a fair procedure. Should the Chief Justice have the power? He said, certainly not. Then how should it be exercised? And Dr. Ambedkar says that it should be exercised by the President. He must have a group of advisors, and Chief Justice, of course, is the best advisor in this matter. So both Article 124 and 217, with regard to the High Courts and the Supreme Courts, were framed. The President shall appoint the judge, in consultation with the Chief Justice. That's simple English language. First deviation takes place in 1993 while interpreting the binding character of consultation. The Chief Justice shall appoint the judge. He may take the opinion of the President into consideration. It's further clarified in 1998 that the Chief Justice now means a group of judges, the collegium. And what happens in 2015 is the Chief Justice, that is the collegium, shall appoint judges. And what was a participatory function in consultation becomes exclusivity. Any involvement of the executive will vitiate the process. That's the basis on which the Constitution Amendment, the 99th Amendment, is struck down. So the original Constitution says the President shall appoint in consultation with the Chief Justice. The Supreme Court says it's the judges alone who will appoint. There is no principle of interpretation of law or constitution anywhere in the world where a provision can mean the opposite of what it says. And today the 2015 interpretation makes it mean the opposite of what the original Constitution says, the opposite of what Dr. Ambedkar had proposed. Secondly, the rationale where it is based on is, and I've read every word of the judgment, and that's why I compared it to your 9 o'clock show, you indulge in a little bit of politician bashing. These petty politicians will do all kinds of things. They will appoint people whom they want to, and therefore the law minister, being a member of the collegium, is vitiated. The Prime Minister and the leader of opposition, along with the Chief Justice, appointing two eminent citizens means political involvement. That vitiates the whole process. And because politicians are wretched people, we must save the institution and make it a Gymkhana club where members appoint new members. And therefore the involvement of these politicians vitiates the whole process, and it's necessary for independence of judiciary that only judges appoint judges. The rationale is independence of judiciary is a part of the basic structure. Of course it is. But then parliamentary sovereignty is also a part of the basic structure. Primacy of parliament is a part of the basic structure. Separation of powers, the parliament's power to legislate is a part of the basic structure. The Council of Ministers is a part of the basic structure. The Prime Ministerial Office is a part of the basic structure. The alternate view represented by the leader of opposition is a part of the basic structure. Now you can't have a unipolar view. You say, well, this is one basic structure, independence of judiciary, and therefore you start diminishing the role of every other basic structure of the Constitution, and then produce a system where this now becomes judicial exclusivity in the matter of appointment of judges. Now I must tell you, to be independent is important. To be credible is more important. And if you have a non-transparent process, I'm afraid in the long run, you may claim independence. You had a CBI director recently who was very independent but didn't have credibility. And therefore, to have credibility, it's extremely important that you must have the checks and balances of a democracy, and these are the checks and balances which Dr. Ambedkar had suggested. The President shall appoint, but on an expert advice. Sure. The provision can't mean the opposite of what the Constitution had said.
Mr. Jaitley, thank you for your opening remarks. You can have a direct confrontation. Why shoot over the shoulders of the 9 p.m. show, sir? I now invite...
No, it's different from a 9 p.m. show because here only one person speaks at a time.
Okay. I now invite on the other side Justice R.M. Lodha. And Justice Lodha, I give you 2 minutes more to balance this out because Mr. Jaitley overshot his time limit by 2 minutes. You have 4 to 5 minutes to make your introductory remarks. Justice Lodha, please.
Thank you. I respect Mr. Jaitley's views, but I respectfully disagree. Of course, the language of Article 124 and 217 is very clear. The President shall appoint in consultation with Chief Justice of India. Consultation cannot be given ordinary dictionary meaning in the context of constitutional provision. Even ordinary, in any statute which comes up for construction before the court, many a time, may is read as shall. Now tell me, which lexicon dictionary says may means shall? It is not. Even the words in Article 368, amendment. Now amendment has been construed to be impregnated with basic structure that destroys the Constitution. Now amendment does not simply mean that. Now consultation in the context of Article 124 and 217, if has been read as concurrence of Chief Justice of India, I don't think judges have interpreted the Articles 124 and 217 directly opposite to what the constitutional makers thought. As a matter of fact, debates in the Constituent Assembly are known to everyone. Even B.R. Ambedkar made it very clear that judiciary has to be insulated from political pressures, political influences. There was, of course, a direct discussion about concurrence, and that was not accepted, and a middle path was adopted. But you know, individuals' beliefs are many a time infected by individuals' experiences, and institutional trust is many a time shaped by institutional experiences. If the history of last 65 years in judicial appointments are seen, in the first 20 years, the fact is, of the 210 appointments, 209 appointments were with the consultation and concurrence of Chief Justice of India. The one appointment where Chief Justice of India's opinion was not accepted was where there was a difference of opinion between Chief Justice of India and Chief Justice of local High Court, not a difference of opinion between executive and the judiciary. And way back in 1959, Govind Vallabh Pant, who was the Home Minister, he made this statement that the involvement of the executive in the appointment of the higher judiciary is nominal. It is the Chief Justice of India whose concurrence matters. Way back in 1959, after the 14th report of Law Commission of India has come, where they wanted to strengthen the consultative process. Now, therefore, after that, what has happened, you know it very well, between 70 to 75, and if I can take you back, the political issue, if I draw parallel, I may not be absolutely wrong when I say, like the executive of the day after 1967, when Golaknath's case was pronounced by the Supreme Court, made it a political issue, to get it overruled, to get it uprooted. The same has been done for last, I must say, almost 18 years. After the second judges came, the untold, unsaid objective of the, I'm not concerned with who the party in power is, the whole idea was to undo what the collegium had said. Whatever objection reason could have been stated on the face of the statute. Just see the contrast. In 1990, when VP Singh was the Prime Minister of India, 67th Constitution Amendment Bill was introduced. And what was the composition of Judicial Commission? Composition was the Chief Justice of India, and 2 judges in seniority of the Supreme Court. Now that was the composition of a National Judicial Commission. Now can Mr. Jaitley explain to me why in 1997, when for the first time a second attempt was made, then in 2003, when Mr. Jaitley was Law Minister, when 2013, when the UPA government was there, and 2014, why the structure of National Judicial Commission, which was introduced by 67 Constitution Bill, was changed. There is no reason forthcoming. It is open to, it is known to everyone. It is known to everyone that after the second judges came, whereby a particular meaning was given to the word consultation, whereby the primacy of Chief Justice of India was retained. Sir. That effort was made to nullify what was said by the Supreme Court in 1997.
Thank you very much, Justice Lodha, for your aggressive counter there to Arun Jaitley. I'm sure he'll respond. Soli Sorabji, you want to take the floor? Arun Jaitley, you want to respond briefly to what he said here? Or will you wait later? You want to respond?
Well, I can...
briefly.
I can just tell you the reason it changed.
Yes.
Because probably in the last 25 years, with no disrespect meant to anyone, the most distinguished Chief Justice of India has been Justice Venkatachalaya. He headed a commission of inquiry, and he suggested a National Judicial Commission on which the subsequent recommendations, with or without some changes, have been made.
I'm sorry,
and therefore, and if you are saying why was it changed, was it because of politics? No. You had India's most eminent Chief Justice heading the commission to amend India's constitution and making a suggestion. Please read Justice Venkatachalaya's report.
Okay.
Justice Venkatachalaya,
and the only difference is a one-member discipline.
That while constituting Judicial Commission, the primacy of judiciary should be taken away.
No, nobody has...
That is the point.
Sir,
that's the whole crux of the matter.
Justice Lodha, if you kindly go into a little more details, Justice Venkatachalaya suggested Chief Justice of India, 2 senior judges. So the UPA bill and the NDA bill had the same composition. Mr. Sorabji was a member of that commission. And then he went on to suggest the law minister and 1 eminent citizen. Now you have 2 eminent citizens. That's the only difference. So according to the present judgment of the Supreme Court, what Justice Venkatachalaya suggested was unconstitutional because it had a law minister and an eminent citizen.
If I may suggest, this argument will be well served in point number 2 on whether the government was trying to compromise judicial independence. We're going to come to it. I'm enjoying the sparring on both sides, but we'll come back to this for round 2 between both of you. Soli Sorabji, your turn, your opening remarks, sir.
We are all agreed that independence of judiciary is an essential feature. No dispute. The question is, in the appointment process, I believe the judges should have an important role, but not an exclusive role. Point out one modern democracy in the world in which our judges exclusively appoint the judges. The collegium system came into being because of the theory of committed judiciary and supersession of 3 judges of the Supreme Court and of Justice Khanna. So intent was good. The idea was to prevent Sarkari judges from being appointed. But over the years, the collegium system has failed. It's not Soli Sorabji saying it. Justice Kurian in the judgment itself, in the concurring judgment, has castigated the collegium system by saying many deserving persons were ignored and many unmeritorious persons were appointed, and that now you have it from a judge of the Supreme Court, the concurring judgment. Question is, I think there's a paranoia. Presence of the law minister, but he hasn't got a controlling voice. He's not a pariah to be excluded. After all, eminent persons is another point which has troubled the people. But who appoints eminent persons? Not the executive. The Chief Justice, the Prime Minister and Leader of the Opposition. And if you had any misgivings that the eminent person may be some politician, there's a well-known technique, as Justice Lodha knows and Rajiv knows, of reading into. You could have read into that provision that eminence must be in the field of law and jurisprudence, and not eminence in the field of politics, music, or other thing. So that effort should have been made instead of striking down the act, that particular provision. When I develop it further.
Sorry, Sarabji. Thank you very much. Rajiv Daman, your turn, sir.
जब अरुण जेटली बोलते हैं तो मुझे बड़ा मजा आता है और जब वो गलत बोलते हैं तो मुझे और भी मजा आता है। गनीमत यही है कि अगर ये पाकिस्तानी होते तो अरुण गोस्वामी इनको बोलने ही नहीं देता। अब इसमें प्रॉब्लम क्या है? वो कहते हैं अरुण जेटली साहब that what is best for India is to be decided by the legislature. Who says so? The Constitution doesn't. The Constitution as interpreted doesn't. Just because they come from the elected part of the country. And Mr. Jaitley would not know because he is indirectly elected to the Rajya Sabha and lost his Amritsar election. So, he has no clue about the electoral process other than he maneuvers it from time to time as he did as law minister. Now let us understand for very simple terms 124 में ये लिखा है interpretation ये है, just forget it. Just remember this. What is your expectation of the Constitution? It has two pillars. One, the democratic pillar, which is governed by the Prime Minister and his cabinet. The other pillar of the Constitution are the not political texts, but the justice texts. The justice text means fundamental rights. It means you can strike down a statute. It means that you can defend the basic structure. आप लोग नागरिक हैं इस देश के, जब आप प्रिवेंटिव डिटेंशन में जाएंगे तो आप कहां जाएंगे? पार्लियामेंट के पास. उन्होंने तो लॉ पास किया है. Where will you go? You'll go to the judiciary. If you want freedom of speech defended so ably by Mr. Sorabji, when Parliament passes laws that are wrong, where do you go? You go to the judiciary. When you want your contracts which are badly done, where do you go? Judiciary. Okay. When you get all these contracts that have been cancelled, where do you go? The judiciary. So understand this. Our Constitution has two trusteeships. The trusteeship of the political texts which belong to politicians. The trusteeship of the judicial texts which belong to the judiciary. Can you imagine a democracy without the justice texts? Answer no. Can you imagine a democracy without the rule of law? Answer no. Now here is Mr. Sorabji saying, look, in other countries this happens. The Senate confirmation will take place. This will take place. The answer is very simple. Indian democracy is unique. We have a parliament that doesn't function. Okay? You go to an MP, you try reaching an MP, you have to go through all the dalals that you can think of. Therefore, please do not consider this, and there Arun is right. It is not legislature versus judiciary. Politicians like Mr. Jaitley, who have been so successful in setting aside contracts, in fighting for free speech, did not turn to Parliament for it. They turned round to the judiciary. Yeah, and it is because the judiciary is there, the citizens of this country say, we have an elected democracy with politicians, but at the same time, politicians are not a law unto themselves. We have a judiciary which is in charge of the justice texts, and it will make sure that there will never in this country be a democracy without the rule of law, or a non-democracy without the rule of law. Now, if we don't defend the judicial texts, where are we going? That is the substance, in fact, of this debate. Forget about the other countries of the world. We can't copy any model at all. Whether it's South Africa, Germany, you just completely forget it. It doesn't happen in this way. Our democracy is unruly, it is difficult, it is intelligent, it is inspirational. It is all these things. but it also doesn't accord according to the rule of law. And in order to achieve that equation, you need an independence of the judiciary. Just before the show, Arun Jaitley asked me, confidentially, he does this confidentially from time to time, he sort of leans over, and he says, "Bhai, tum NJAC ke saath ho." The problem with the NJAC is not what they are talking about, this general stuff. There are design faults in the NJAC. And what Mr. Jaitley is saying, and Mr. Soli Swaraj is saying, absolutely wrong. Which is, soon after the Constituent Assembly debates, the 14th Law Commission said concurrence. That is the direction in which it moved. And this continued. Now, why did the judiciary have to take over? And the answer is very, very simple. Do you remember Shiv Shankar? Hansraj Bharadwaj? Yeah. Law ministers who dominated appointments in the 80s. And so the judiciary in 1982 said, look, consult us properly. But when this process of political manipulation started, I know I've sat in judges' houses when they say, Bharadwaj sahab aa rahe hain, jara dusre kamre mein chale jao. Now the question is, when this happens, the judiciary, just 1 minute, a judiciary goes on the back foot, and finally in 1993, it says no. We will consult the executive. It isn't a question of the executive not being consulted. We will confer with them. But what we don't want is the error that we have gone to, which led to 1993.
Right. Mr.
For
Dhawan,
the moment, that will do.
Mr. Dhawan, thank you for your opening remarks. I could see there were 7 references to a person called Arun Jaitley, so you were trying to draw him in. Mr. Jaitley, would you like to respond, or should we go to the... Should we...
8 references.
8 references. Well,
Thoda maja hai.
Well,
Mr. Jaitley.
He forgot the 9th reference because Rajiv lives in a fictional world. He says, where would you go if you were detained? On this dais, I am the only one who suffered a detention. And I...
Jaitley sahab, bahut saal ho gaye.
Therefore,
Okay,
I'm just trying to correct your sense of history. I am the only one who suffered a detention. I followed Rajiv Dhawan's advice and went to courts. And the courts told me the doors are closed for you. So much for your... So you've forgotten the emergency.
Emergency ki baat kar rahe ho.
Okay. We're coming to the free debate round, sir.
You started with. Now this whole argument is based on 2 premises. And that's my problem with this judgment. Make a general political speech, and that's what I repeatedly said 9 o'clock show. Damn the politicians, and therefore say, because politicians are bad, we must usurp the power because judiciary per se is good. That's the argument. A constitutional court has to base the interpretation of the constitution on a constitutional principle. Politicians are bad, so let's hijack the constitutional power. This is no constitutional provision. There is no constitutional provision anywhere in the world that democratic institutions have to be saved from the elected. And the elected are per se bad. Now, if this example applies the other way around, you go to parliamentarians through dalals and they don't listen to you, so let's hijack the power.
Let me,
Rajiv.
say that, Mr. Jaitley.
Let me answer.
I didn't mention hijack even once.
No, I'm using, that's the answer. Because if we lumpenize the argument to this level,
this is not
then somebody else will come up and say, oh, there are 3 crore cases pending in courts, the judges are not doing their power, and therefore they are not doing their job, so let somebody exercise this power. I think such an argument, either for the legislature or the judiciary, is completely destructive of the Constitution. Every institution must do its job. The parliamentary primacy and sovereignty is a part of India's basic structure, and this, just as basic structure has to be protected from the executive, the Supreme Court says basic structure has to be protected from the legislature. The basic structure also has to be protected from the judiciary, and separation of powers is a part of that basic structure.
Now I would like to proceed to the substantive part of the debate. We've had introductory comments which are quite interesting. Mr. Padgaonkar, you wanted to come in at this stage? Then I go to the four key points.
I'd like to ask a question to Mr. Jaitley first and then to both of you here. You know, so much of this debate has been around who should appoint the judges, not how the judges should be appointed. I think this process is something that needs to be clarified, because once everyone agrees that the separation of powers and the principle of checks and balances is to be maintained, then it is the process that is, in my view, far more important than who does the appointing. This is one question to you. The other question to your side is that there is a possibility of keeping a watch on two other agencies of the Constitution, namely the Executive and Parliament. There is none at all under the collegium system to do likewise. The collegium system has been opaque in its functioning. The collegium system has been unaccountable to anyone. And therefore the question to you is, what is it that one needs to put in place which will allow for a proper balance between the twin needs to be independent and to be accountable?
You want to take those two observations. Swapanda also wanted to come in with a couple of points there. I want you to note these points so that you address them in the course of the next four sections which we are going through. Mr. Dasgupta.
Yeah, I was referring to Rajiv Dhawan's admission that there is, or confession that there is a design faults in the NJAC which really have to be remedied. I would like to ask him, or for that matter Justice Lodha, that I was really struck by one sentence in Justice Kera's judgment, which is reported in the media. I haven't read the voluminous text. And the judge said that it is difficult to hold that the wisdom of appointment of judges can be shared with the political executive. In India, the organic development of civil society has not as yet sufficiently evolved. Now, does this imply that the judiciary must really preside over and be a mentor to an ignorant people and therefore be shown the actual path? Isn't that the implication of this very revealing sentence?
Would you like to respond, either of you, to this? Or include it in your debates later?
No, I can respond right now.
Go ahead, Mr. Dhawan.
First, I want to respond to Mr. Jaitley using unkind words like lumpen, living in a fictional world. Make up your mind what I do. I'm a struggling lawyer, and you are not a struggling politician. We are concerned with a constitution operating in the way it should be.
Sir.
Mr. Swapanda Dasgupta, you don't read judgments by pulling out one line from a newspaper.
But I just want you to comment on that one line.
Okay, Mr. Dhawan.
Now, I want to tell you what the design fault is, if you just permit me. The design fault is that there are 6 people in this NJAC. Now, 6 is an even number. How are you going to deal with it if it's a 3 by 3? Some politics is going to take place.
Okay.
The 2 eminent persons include somebody who would be a member of the minority, or a woman, or SC/ST, or OBC. Now, the patronage there will be 2 politicians and the Chief Justice. So all that they have to do, and that's the design fault, if the politicians manage to persuade the 2 eminent persons and 1 judge, they will succeed.
Mr. Dhawan, now let's...
So please bear in mind, it is that
Mr. Dhawan.
Mr. Jaitley asked me, one second,
Mr. Dhawan.
Mr. Jaitley asked me why I don't like the collegium system. There are things wrong with it, but we can make it better.
Okay, Mr.
But
Dhawan.
where you have a design fault, it cannot
Mr.
be
Dhawan,
made better.
now let's go to the...
I'm doing what you normally do at
No,
my
you
court.
don't have to do that.
Okay.
I'm not flattered, sir.
Please be.
I think I would like to go, Mr. Dhawan, with your indulgence, to the principal part of this debate. I said at the start, and I only make a request out here, if we can keep it completely on the subjects at hand rather than on a personal attack, I think our audience would far more appreciate it, sir. My first question today is on whether the NJAC verdict, the Supreme Court verdict, destroys or damages partially or entirely the idea of parliamentary sovereignty, and I put it to this side. And this question goes to Mr. Jaitley and Mr. Sorabji. Either of you can answer it. Mr. Jaitley, specifically to you. And now we go into the freewheeling debate where the panelists can come in at any time. Once I ask the first question, it's open to you. Mr. Jaitley, I start by asking you. You have used the controversial phrase, quote unquote, tyranny of the unelected in the context of the NJAC judgment, even saying that the Supreme Court's upholding of one basic structure of the Constitution has come at the expense of upholding others. However, let me ask you, Mr. Jaitley, is the Supreme Court exercising its right to interpreting the Constitution and striking down an amendment that it feels does not fit within the parameters of a basic structure of the Constitution, an example of the tyranny of the unelected? Isn't the judiciary as accountable to the Constitution of India to interpret it and to do it justice just as much, if not more, than what the Parliament is? Mr. Jaitley, your opening comments on this, and now we're into the freewheeling debate. Go ahead, Mr. Jaitley. You can intervene anytime.
I think I must put the argument in the correct perspective because your question indicates that it needs a clarification. The Supreme Court is entitled to strike down a constitution amendment. Correct. The Supreme Court can legitimately say that it violates the basic structure and therefore it's unconstitutional. I have no difficulty with that. That is not tyranny of the unelected. My phrase tyranny of the unelected in the blog is used in the context that if you start on a constitutional argument that the institutions in a democracy have to be protected from the elected, you will end up creating a tyranny of the unelected. That's the context in which I use, not for the judgment. So let me be clear. And secondly, while you ask me the question, let me just respond to the structural defect. What happens if 6 people, there is a tie? In the third judge's case, 1998, when the Supreme Court created a collegium of 5 judges to appoint judges of the Supreme Court, one of the conditions they mentioned was, what if there are 2 views about a candidate? Should he be appointed? Because once a dubious person is appointed, then he's there till ever. If 1 out of 5 dissents, it's a dissent. But if 2 have an objection, then it's more than a dissent. The person can be ignored. So just as in a collegium of 5, if 2 people object, the name has to be dropped, and that's a convention which has been followed till date. The same convention is statutorily incorporated in this in the law itself. If 2 out of the 6 members say somebody is very controversial, let's keep him out. Therefore, if there are 2 views on a person, let's not have him as a judge. How is that a structural defect in the judgment?
So watch. So you stand by your phrase. Justice Lodha, please, Justice Lodha.
First, coming to the comments of tyranny of unelected, I really did not believe that this has come from Mr. Jaitley. This could have been the language in 75-76 against the judiciary, because anyone who knows the Constitution, anyone who understands the constitutional functioning, Constitution has provided elected representatives of people to make law. They have been empowered to make law within the limits that Constitution provides. They are elected representatives. But at the same time, India has not followed a US model where large number of judges are elected. Now about American judges, what people say? What they say is they're hardworking, they're intelligent, but he was a lawyer once he knew a politician. So do you want a judiciary where people say, looking at the judge, that he was a lawyer once he knew a politician? Now that job, making of laws, is of the parliament. But what the law is the domain of the judiciary. And Alexander Hamilton, who was one of the founders of United States Constitution, he said, if Parliament, if the Congress makes the law, which is in opposition to the Constitution, judges ought to follow the latter. Now, judges, they would be failing in their duty if they do not strike down the law which destroys the basic feature of Indian Constitution. That is the mandate given to the judges. Now, what has been done? Look, when Mr. Jaitley says, yes, there is a power of judicial review with the judiciary, he also says that, yes, if legislation hits the basic structure, it can be struck down by the court. That is what exactly it has been done. Now, there are different ways of reaching the decision. And as Dr. Dhawan has said, there is a design fault on its face. Whatever way you look at, the composition of NJAC takes away the primacy of judiciary and leaves the choice in the hands of either two eminent persons.
Justice Lodha, can I just respond on a particular point? First of all, Justice Lodha, please read my blog once again. I've clarified it to you. Judiciary is not the tyranny of the unelected. The argument of the Supreme Court that the democracy must be protected from elected representatives will create a tyranny of the unelected. And let me tell you, when the judgment and those who support it run down politicians, two of the most distinguished judges India has had since independence came from the field of politics. Krishna Iyer was a minister.
No, I can assure you.
Krishna Iyer was a minister.
There is neither
Krishna Iyer.
Nor judiciary does it.
No.
I tell you, I was staying as Chief Justice 5 Krishna Men in Marg. Whenever in the morning I will go out for a walk, a Parliament House is before me and I'll bow down. Because that is symbol of democracy. How can any judge run down politician or
But the judgment does.
No, look.
The judgment does. Please, Justice Hegde, the superseded judge of 1973, was a member of Parliament before he became a judge. And therefore, a presumption that politicians will create hell, and therefore, because I am an institution, I alone have to save this country, I don't think is a fair proposition. You need a balance of the three institutions in order to democracy to survive.
See, we are on the first point. The first point is, did this Supreme Court verdict damage parliamentary sovereignty? I'll come to judicial independence later. See, my point here is, I just want to steer this.
I want to respond
While the Supreme Court... No, you can respond to him, sir.
No, not to him. On that topic.
Sure, sir, you respond to the subject. Respond to me. Respond to me, Jarajit.
Yes.
See, while the Supreme Court is well within its right, Justice Lodha, I respect that. And I want this point to come in, to strike down any law that it says is unconstitutional or violative of the basic structure of the Constitution, the doctrine. I want you to address the point of whether the judiciary, with all respect, has transgressed into the legislature's domain by reinstating the collegium system which stood repealed. The court can say, yes, the NJAC is ultra-virus. But shouldn't it be the prerogative of the parliament to put in place an alternative law? Did you therefore wade into the territory of the legislature, which is why there has been such a strong response from this end? Sir, you're not addressing that point yet. Please address it directly.
May I just add that therefore,
go ahead.
Under the circumstances, if the NJAC is violative of the basic structures of the Constitution, shouldn't it have been the right of the Supreme Court to have restored Article 124 in its pristine purity? Because after all, that was the law made by the Constitution. That is the law as deemed by the Constitution. Is it in the domain of the Supreme Court or any other court to actually make law?
No, this is...
Are you therefore usurping legislative powers?
I'm sorry, this has not been done. It is very easy to say that Supreme Court has usurped the legislative power. It's pure construction of Article 124 and 217, and the important part is second judge's case actually says three things. It says that appointment of judges to the Supreme Court and the High Courts is an integral part of independence of judiciary. independence of judiciary is basic structure of the Constitution. No law can be made or nothing can be done that takes away that primacy of judiciary. Now, primacy of judiciary, look, if you read Article 124, it does not talk of collegium. It talks of Chief Justice of India. Now, Chief Justice of India has been construed as collective body of judges. So therefore it is thought that no absolute power is given to an individual.
Yeah, go ahead.
So therefore I really don't understand. And to say, like Mr. Swapan Das Gupta has said, why should not have, after NJAC was declared unconstitutional, to restore Article 124 in its pristine form? Now, what is that pristine form? Is what has been interpreted by the Supreme Court. Now, in M. Nagaraj case, in other cases, now Supreme Court has said that you have to take into consideration the interpretation of a constitutional provision that has been given by the court to understand the width and scope of a provision. They have applied the width test, they have applied the identity test, and these tests have been applied to even identify what is basic structure of the Constitution.
You want to respond? I counter, sir. Sorry.
I have something to say.
Sure, but although the doctrine of separation of powers has not been given a constitutional status, has that principle, sir, please address the point, has that principle been compromised with unelected members of the judiciary framing laws?
I make it very clear to me, it is very clear that Parliament is within its power to make the law, to amend the Constitution under Article 368 of the Constitution of India. The only limitation that is put upon the Parliament is that by such amendment, the basic structure of the Constitution should not be destroyed. Nobody says, and even not a single word in 1030 pages of the judgment says that Parliament has no power to amend the Constitution. It doesn't say that alternative system of appointment of judges could not have been made. What it says is the alternative procedure which has now been adopted hits the basic structure of the Constitution.
Arun Jaitley. Sir, Arun Jaitley.
The issue in 2015 judgment is not even primacy of the Chief Justice. The issue now is exclusivity of the Chief Justice in the matter of appointments. Because if you read the 2015 judgment...
Sir, it is not. As Chief Justice of India, I can tell you, as I have found, yes, I have felt that the system, collegium system, has faults. And one of the reasons for its being faulty is the executive's stand that it is merely a post office in consideration of proposals for amendment to the High Court judges and Supreme Court judges. I have seen there was a proposal from perhaps Madhya Pradesh High Court, and a complaint before the disciplinary committee was pending that was not disclosed. Whatever complaints were received by the law ministry were simply sent to the Chief Justice of India.
Justice Lodha, let him complete, but I want both sides to address a basic point of whether the Supreme Court was usurping legislative powers by not just replacing the NJAC with the collegium system, but further wading into Parliament's domain by rectifying the flaws in the system on its own. Arun Jaitley, please respond. I'm coming to Rajiv.
I don't think in the process of judicial review, the Supreme Court hurts parliamentary sovereignty, because Supreme Court is entitled to judicial review of the Constitution amendment. I'm conceding that. That's always been the position, that should be the position. But in the process of judicial review, the propositions that they lay down, that if any part of the legislature or the executive government is associated with the appointment process gets vitiated. The rationale of the Supreme Court judgment is, it's not the primacy of the Chief Justice, it is virtually the de facto exclusivity of the Chief Justice which is important. And if Law Minister sits as one representative out of 6 of the executive, his presence itself vitiates the whole process. And therefore, in the concept of separation of powers, the content and the text of the judgment itself does extreme damage to the sovereignty of Parliament, to the rights of the executive to have a say. Now, under the original constitution, the president had to appoint in consultation. Today, the Chief Justice and the Chief Justice alone will appoint. If the law minister sits in the appointment process, the appointment is vitiated. That's the law. And therefore, it is the interpretation which goes contrary to the separation of powers. That is my
So you do accuse the judiciary of deliberately wading into the legislature's...
Every academic argument is not an accusation, Arnab.
Sir.
We are exchanging an academic argument. And therefore,
how would you phrase it?
Therefore, my academic point of view is that for democracy to survive, there have to be checks and balances. After all, the Supreme Court has said, and rightly so, that there must be no absolute power. The power of appointment is not a judicial power. It's an absolute power. If the executive exercised it, it would be subject to parliamentary discussion. It would be subject to judicial review. What if the Chief Justice of India exercises executive power and says nobody else in the world can review this power? The power is exclusively mine.
Rajiv Dhawan had a counter, please. Do you have a counter, or should I move to point number 2?
First, let us address the question. Does this mitigate the sovereignty of Parliament?
That's the point.
The answer is no. Why? Because Parliament is not sovereign. There is a supremacy of Parliament in its own sphere. There is no such thing as the sovereignty of Parliament as we understand it, borrowed from the English. So Parliament is supreme in its sphere.
Rightly so.
Now, who is supreme, the supreme custodian of the Constitution? That is the judiciary. Now, by conceding that judicial review is okay, basic structure is okay, now let us test that. Parliament passes a law, the judges strike it down. Have they interfered with the sovereignty of Parliament? No. Parliament passes an amendment ratified by one half of the legislatures. It is knocked down by the judiciary on affirmative action, Nagaraj's case. Is that a violation of the sovereignty of the people through Parliament? No. Parliament is supreme in its sphere. If we wanted to give Parliament absolute powers, the Constitution would have done so. It's as simple as that. Now let us come to the judgment itself.
One sec, I want a counter to that specific point.
Are you saying that we determine what is the sphere?
No.
And
no,
therefore,
yes, yes. See,
all three organs derive their jurisdiction from the Constitution. Look, unlike United States or Australia, there is no express provision in Indian Constitution separating the three organs. But it's a very sweep. It's so visible that you find that all three organs are separate and they derive their authority, power and jurisdiction from the Constitution. And therefore I agree with Mr. Dhawan. So far as parliamentary supremacy is concerned, it is twofold. One, that it makes law within the limits of the Constitution, and it has...
Justice Lodha, who will question you?
Supremacy...
Who will question you? I mean, you have a rare show of unity among both parliament houses on one side, later ratified by 20 state assemblies on the one side. And by the way, with respect, the NJAC was not an afterthought. It was not a law passed in an arbitrary manner. It had the backing of high-level committees since 1989. Who is going to put any caveat to what you think?
Discharge of judicial function, a rule of law will have no meaning. I have said, if discharge of judicial function is made subject to the will of the representatives, elected representatives.
I want to finish my point.
Attempt to reconcile judicial review with the parliament's supremacy is, I believe, sure recipe of destruction of rule of law.
Arun Jaitley, the other side, please. I'll have I think I have a very critical
I have something to say.
Yeah, come back.
Prior to the 1992-93 judgment, leave aside the aberration of the 1970s, the first part of 1970s, where judges were superseded and the emergency was proclaimed. Leave those 5 years out. From 1950 onwards, you had the best quality of judicial appointments made, even without the so-called primacy or exclusivity of the Chief Justice. The fact that Chief Justice recommended, the governments would appoint and the governments would go about it. the governments have been consistently appointing chief election commissioners and election commissioners. Governments have been appointing the CAGs. The governments have been appointing the CVCs. Have these institutions become compromised institutions merely because governments appoint them and politicians are what Dr. Rajiv Dhawan thinks they are? Now, you have constitutional institutions existing in this country, appointed by governments, which have functioned exceedingly well. You had the pre-93, and I'm speaking for myself, with whatever little I know, barring the 1970s first 5 years, the pre-93 appointments were unquestionably better than the post-93 appointments.
All right.
And if you see, some of your tallest judges have been appointed in the 50s and the 60s by the original provisions. Therefore, in 1993, to twist it to say primacy, speaking for myself personally, I have no problem with primacy also. Where I say parliamentary and executive powers in their own domains have been hit is 2015, when we today don't have primacy, we have exclusivity. That's where the Constitution is violated.
Two things I think that are necessary to understand. We are not politician bashing. Politicians bash each other enough. So leave that out of the equation. We are concerned with the structure of this Constitution. And the greatest power in the Constitution is vested in the judiciary. Also, it is incorrect to say that what was taken objection to was the law minister. Mr. Jaitley's predecessors, when he was law minister, in the 80s were awful. They made appointment after appointment, which they should not have made. I checked up Mr. Jaitley's appointments when he was law minister. They were not up to scratch. How it happened, I do not know. I checked them this afternoon. I read everything this afternoon. Now let us come to the subject. Sovereignty. Nobody's sovereignty is compromised. When constitutional amendments were struck down, there was no khundak. What is the khundak here? Law minister is objected to. Nobody is objecting to the law minister.
I now bring you to point number two. I'm bringing you to point number two.
I want to answer one more point of Mr. Jaitley.
Let me bring you to point number two.
No, 1 second.
The point, you can continue, but I'm introducing point number two. My point number two in this debate is, a fear has been created that the entire concept of judicial independence is under some grave threat. I hope my co-panelists agree with me on this. Mr. Padgaonkar, you agree? A fear has been created that here is this terrible law, the NJAC, which will severely and totally destroy the concept of judicial independence. I allow you to continue, so I'm only stating like I had made my first point to Jaitley, I make it to you.
All right.
My point is, and I would like Swapan Dasgupta to articulate it and then this debate can go forward, has a fear of a major, terrifying say by the political system been overstated? You have 3 members of the Commission, which are judges, right? How is it then tantamount to reducing the role of the judiciary? If a 2-member veto is seen with suspicion, it can be argued that 2 judges can also come together, as Mr. Jaitley argued earlier, and they will be seen to be representing one side. So there need not be 2 eminent people who are appointed by judges. 2 judges can come together and block the entire system. My second point, therefore, is, does this law really compromise on judicial independence? Please, this side, please have its first say. And you can respond to that. Continue. Either of you, Justice Lodha or Rajiv Dhawan. Sorry for the interruption.
Problem with this is, yes, so far as rejection part is concerned, yes, this composition takes care. What about appointment of independent judges? The Chief Justice of India and the 2 senior judges find a person highly suitable, a man of integrity, total impartiality, knowledgeable, a man of learning, to be judge of the High Court or the Supreme Court. Now, either of the lay person and law minister or 2 lay persons, they say they are not. So that takes away right of judiciary to appoint right person to the post of judge of the High Court and judge of the Supreme Court. This is fundamental flaw with this NJAC.
There's a fundamental flaw, Justice Lodha, in your argument. Where is the proposition that only judges can appoint independent judges and everybody else would appoint only evil men?
Total red herring.
After all, when you did not have a system of only judges appointing judges, you had some of the most outstanding appointments which were made in this country.
This is a complete red herring.
No, continue the debate.
And it's a red herring for this reason. Mr. Jaitley, responding to the number of 6, said that earlier if 2 said no, that would be enough. Now, which are the 2 here going to be? The 2 eminent persons? One from scheduled caste, one from OBC, one from minorities? How are you going to get
Swapan Dasgupta, I'm allowing the counter.
Hang on. Are you suggesting that they can't think? Are you suggesting that such people can't think?
No.
That was the implicit.
I'm suggesting.
You are suggesting that.
Mr. Swapan Gupta.
Extremely patronizing remark.
Mr. Swapan Gupta.
Dasgupta.
I am Das Gupta, whatever Gupta you may be.
No, the name is very important.
I am simply saying to you that you don't understand the Constitution and how it works.
You do. You have a monopoly, sir. I concede
I've spent
that.
my life serving it. But let me understand. I want to respond.
Dilip Padgaonkar, you will respond.
Listen.
Dilip Padgaonkar has a democratic right to counter you. Go ahead.
No.
Exercise your right.
Rajiv,
exercise your right.
Look, listen. Under both the models that we've tried, namely the consultative model as well as the collegium model, there have been very serious mistakes committed. 70s, the consultative process yielded the worst. When from 73 onwards, judges were superseded. During the emergency, what happened? During the Janta regime, partly it happened. Then after Ms. Gandhi came back to power, again judges were voted out and so on. That was the excess. But under both the systems, you can give examples where the models haven't worked. Now, you mentioned, Justice Lodha, about a particular candidate that the collegium had forwarded, that was turned down.
No,
Anyway, let me just finish.
Inputs which were required from the executive did not come.
Very well, but there was also...
The problem is the integrated, participative, consultative process which Article 124 and 207 speak of has not been taken in the right spirit by the executive.
Lodha, let me just say, you mentioned this example, but there is another well-known example of a certain judge, Justice of the High Court, whom we wanted to elevate to the Apex Court, and it is the Apex Court which withdrew that because of a huge controversy regarding the character of this particular judge. So there have been, on both models have erred.
No, I can tell you. I am not on, because if you are referring to a recommendation made by me and that controversy, I can tell you, if the executive is particular as they were, in that case, no bad appointment will ever happen. The problem is we are not getting the inputs from the executive which are expected from them. Look, see, cases after cases, the IB reports, the law ministry's comments, they're absolutely of no use. Whereas, the effort on the part of the executive must be to give very fair and frank opinion, so that...
So, Justice Lodha, you don't trust the executive?
No, we trust.
You have a problem of faith and trust. No, you have, you have a problem of...
On the other
Justice
hand,
Lodha.
I repose full trust in the executive, but what I want is that they must take full, they must play full participative role, give their honest opinion, then live it. Then let judiciary consider that and find out whether the objections are meritorious or not.
So the judiciary must have the veto, the first say and the final say.
There is no question of that.
Arun Jaitley.
Justice Lodha, I don't want to get into individual cases, but I must have, as law minister, processed hundreds of files of recommendations which came. There were not one or two, but a few dozen cases on which there were several adverse reports. There were many cases on which people should never have been appointed. Strong opinions were given. In one case, the Prime Minister and I sent the file back with a strong opinion. Within 24 hours, it was re-recommended back. Thereafter, President Kalam in his own hand wrote, the reasons why this gentleman should not be appointed. In 24 hours, you overruled President Kalam. You appointed the person. After you appointed the person, after 2 or 3 years, you realize that this man should never have been appointed. Then you had to non-confirm him. So you'll understand the case I am referring to. This is the executive recommendations have been treated most lightly, never taken seriously. As of today, under the system that prevailed, and I'm saying this on basis of hundreds of files that I have tackled, it's de facto a system on which the executive has to follow what the collegium says. There is no participatory role. It is a ministerial role. It's a clerical role.
I want to come back to the question of trust. I think there's a problem of trust. And please don't run away from this subject, sir.
Nobody is running away from it.
Address this question squarely and fairly.
Look, no,
I want to ask you here, sir. Can I please draw you in a bit?
As long as you don't treat me like a Pakistani.
No.
On your show.
No.
That's fine.
Sir, if the principle that a judge is appointed by a panel in which politicians have a say may feel gratified to those politicians, so that's the basic argument. He will feel so gratified to the politicians that the person can't be trusted. Sir, please tell the august audience today, what about the appointment of the CAG? What about the appointment of the election commissioner, who play as much, if not more, a critical role in maintaining an eye of the government of the day? For example, the UPA government will testify to the fact that Vinod Rai did hardly anything that was their bidding, and Mr. Jaitley or others from the BJP may have similar views on Mr. J.M. Lingdo. So I want to ask you whether your argument that nobody else but we can be trusted with appointing people who will uphold Indian democracy can really be considered to be the last word. Please address that point, sir.
The answer is simple. There is no finite division between the judiciary and the politicians in power. Okay? There is no. When the collegium was in show, then appointment suggestions came from the executive. Please bear this in mind. The collegium discusses with the executive, and then it makes its internal decision. Therefore, even under the collegium, we are meeting on the 3rd of November, and the judges want to decide how can we make the collegium more transparent, more accountable, and more
So you're not addressing the question.
Now the answer to your question is, you can't compare the judiciary with the CAG, the election commissioner, etc.
Sir, please.
You simply cannot.
Okay, fine. If I were to counter that by asking you, and let them respond, the question is, and Justice Lodha, please.
The answer to your question is, there is only one objection that they have.
Judiciary's role,
more political power.
Judiciary's role is entirely different from the institutions you are referring. CAG or Election Commission will not decide the cases like coal block allocation. CAG or your Election Commission will not decide the cases spectrum. CAG or Election Commission will not decide even a case relating to validity of Section 8(4) of Representation of People's Act, which disqualifies a convict. Now these are the cases that come to the court that actually have wide political ramifications, and therefore role of comparing judiciary with independent.
One second. So vested interest is the argument, conflict of interest and vested interest. Go ahead.
Of course, they have different jurisdictions. We all know Election Commission doesn't decide cases, only Supreme Court does.
Of course.
But the fact is,
then why raise the question?
That the Election Commission is not gratified to the government. It remains an independent authority even if it's appointed by the government. The CAG on coal block allocation is capable of and has given a report as independent as the Supreme Court could do, even though the CAG is appointed by the government. So governments are capable of independent appointments. The premise in the judgment that whoever the government appoints will be gratified, that is not an argument which holds any basis.
Rajiv Dhawan or Mr.
I think there Mr. Jaitley is correct. There is a passage in the lead judgment which goes into the psychology of give and take. that passage should never have been there in Justice Kehar's judgment. So I think as far as that is concerned, he's absolutely right. The question that concerns us is this.
Right.
Participation will still take place on both sides. But you cannot have politically appointed judges.
Of
and
course
if we
you
don't
can't
understand that, then we don't understand.
Rajiv, of course you can't have politically appointed judges.
You can't have them.
But you must have judges appointed by a process where there are checks and balances.
Yes.
You can't have politically appointed judges.
Now, what is the checks and balances here? One law minister plus two eminent persons appointed
and
by
three judges.
Going back to that issue.
And three judges.
Where are we going with this?
And a law minister
Therefore,
with a history, as Justice Lodha pointed out, that in 50 years, except one, every recommendation of the judiciary was accepted.
Now,
so the executive has a glorious
Mr.
role.
Jaitley, I've heard you on basic structure reversals. I've never heard you this anxious. And the reason could only be you want something more than the law minister there.
I am.
So I don't know what you're. I understand if you were to say. No, 1 second. Let me finish, Mr. Jaitley. I can understand if you were to say that the process of consultation should be deeper than it is. I could also understand more views. I mean, if you say that when you were law minister, you were treated like a postman, your advice was not taken into account. I mean, in the first place, it's not correct. But the idea is both will participate, but the final answer will be with the judiciary. That is the correct way to read
Can
this.
the collegium, can the National Judicial Commission ever make an appointment which is vetoed by the judiciary? Of course it can't.
No, it can't. That's the whole point, Mr. Jaitley.
How can it? If the three judges say no, can an appointment ever be made?
No, but can't. You are right.
It simply
But
cannot.
The independent people who judiciary want to appoint, they can be stalled. That is the whole problem. Look, Mr. Jaitley, you know it very well. And look, I can tell you my personal experience because I had met the President UK Supreme Court Neuberger in London and the Chief Justice South African Court. Now let me tell you, in England, Lord Chancellor, as you know, was everything. He was Speaker of the House, he was Law Minister, he was Lord Judge, he would appoint. Executive. Now they have in 2005, by Constitution Reforms Act, brought in Judicial Appointment Commission. Now that 15 members they had, just hear me, 15 members that they have, there is no politician, no executive participation. What they have is, and I had a long discussion with Chris Stephens, who is chairman of Judicial
Justice Lodha, in that 15-member commission,
there is not a single
everybody else except the judges excluded in England?
No.
Therefore, you have an example in England. And when we follow this example in India, you say judiciary is under threat.
But you are constantly talking about...
Just one minute. No. So the moot point is what your allegation is, and Mr. Jaitley address it. The allegation is...
My allegation against Mr. Jaitley is this, that this whole phrase, tyranny of the unelected, all the entire argument so far has been, you should not have a judiciary which is totally outside executive control.
That's not the argument at all.
Now then, that is the only argument you've made so far.
Rajiv, I think you need to look at various other institutions to see how democracy in India functions. When I used to, it's quite easy for somebody who's exclusively in the court to say the court must have primacy. Similarly, Parliament can say we are elected, we must have primacy. Under the Indian constitutional system, you need a system of checks and balances. The power of appointment, which is an executive power, which was intended to be exercised in a particular manner, you can't now say by a process of interpretation it will be exercised in exactly the opposite manner, and the executive power must now belong to the judiciary. You must have independence of judiciary from the executive, you must have independence from the legislature, but there is no proposition that only judges can appoint independent judges.
Let me ask you, Mr. Jaitley, let me ask you this. Now you need to, if this debate is to go anywhere, you need to satisfy them that you're not trying to trample over them. Now the primary concern with the NJAC, Mr. Jaitley, is that it doesn't retain the primacy of the judiciary in judicial appointments. Am I correct on that, sir? Right? Now I ask you here on this, how can it ensure primacy? If I argue on the other side is, when 3 judges on the panel can be overruled by any two members, the law minister and at least one eminent member or both eminent members can strike down the choice of the three judges.
Or put it another way, would it help if the law minister was discarded from the selection panel?
If I may follow, sorry, Mr. Jaitley, if I may follow, how can there be primacy of the judiciary when the process to choose these eminent persons involves a committee that includes A, Prime Minister of India, B, Chief Justice of India, and C, the leader of the opposition? The political class, even in that selection, has a greater representation in the selection of these eminent persons. So point is that you have sort of firewalled yourself on this issue. Please, no, you can address that.
That's the checks and balances. That composition itself is checks. You have the government, the Prime Minister, which is the most important accountable institution in a democracy. You have the leader of opposition representing the alternative space in Parliament. You have the Chief Justice of India. If in Indian democracy this eminent panel can't be trusted, then I'm afraid nobody else can be trusted.
We come back to trust. The constant argument on this side is you don't trust the governing classes. And you don't trust the politicians. So it's coming back to that point again.
Arnab, we've discussed a lot on this accountability. Politicians are condemned, but every evening we are accountable to the national media for every statement we make.
Are you, sir?
Next morning, the print media writes editorials against us. In every election, we are accountable to the people. We are accountable in Parliament. Does any other institution have that standard of accountability with Indian politics?
Mr. Sarabji wanted to come in on that point.
There is an answer to that.
There is none of the organizations or agencies who are talked about. Court is an institution which is under public gauge all 24 hours. In the open court, hearings are made. Now it is not, nothing is secretive. So there is no question what every judgment that the judge delivers, make him accountable.
Solely Sorabji.
Yeah. Justice Lodha, I don't think if the act is properly construed, reading into a certain requirement.
Sir, the problem was
let me complete.
Sorry.
It really makes the voice of the judiciary completely ineffective. It's not mute. You know, the Supreme Court has said, first of all, I agree, you can strike down a constitutional amendment if it affects the basic feature. No question about it. There's no question of parliamentary sovereignty. That I don't agree. But it can't be on ifs and buts. One surmises, one suspicion. The whole question is, you think some people will do this, some people will do this. It's not James Bond play.
Nobody works like that.
The whole question is, you have to realize that in this matter, I agree, judges are the most appropriate persons in making appointments. They know the judges, they know the laws, but they're not the exclusive body. That's the whole point. And that's why no one has referred to the dissent of Justice Chandrashekar, who's very well brought it out. Actually, that's the whole thing. Sir. Why do you want to arrogate this power completely to judiciary, not have other voices?
Okay.
Other voices may not prevail. In my opinion, properly understood, the voice of the judiciary is not mute, not ineffective.
Okay.
If I'm not wrong, it was Soli Surabji who said, I would rather trust judges than executive in appointment of judges.
Yeah.
This is the answer to all this.
I would. Judges, yes.
So therefore,
but not judges exclusively.
If judges are to be trusted,
No, but he said judges, yes, but not judges exclusively.
No.
He stands his ground, sir.
Nobody again.
No, he says you're misquoting him. Justice Lodha, you're being accused of misquoting.
Five judgments which collectively ran into 1030 pages.
With dissent of Chandrashekar.
Do not say that there cannot be an alternative mechanism for appointment of judges.
Okay.
No.
See, if you are quoting Mr. Soli Sorabji, the man who gave birth to the collegium was Justice J.S. Verma. And I'm sure later on in his life, what his opinions were about the collegium, you equally are aware of that.
After he retired.
Okay.
May I just...
Dilip Padgaonkar has a point, and then we are going to the controversial point on whether the Supreme Court tried to deliberately rewrite the Constitution to arrogate powers to itself. I think that's a critical point, but before that, Dilip Padgaonkar, go ahead, sir.
You know, even as you're contemplating ways and means to make the judiciary more accountable and function in a more transparent manner, I have one specific question to ask. Whether the competence of the judiciary is not, in a sense, compromised by the fact that so many judges who retire get sinecures from the government after they leave.
Right.
Is there any possibility
Absolutely.
of saying that if you are a member of the apex court or any other high court, you will not be entitled to a sinecure?
I fully agree with you, and I respect Jaitley's comment that pre-retirement judgments are influenced by pro-retirement benefits.
Absolutely.
As a matter of fact, the day I took oath as Chief Justice of India in the Rashtrapati Bhavan, when Rashtrapati ji was sitting, the then Prime Minister Manmohan Singh ji was there, Vice President was there, I had suggested, Law Minister was there, that time has come where you must devise a mean so judges or accusation which has been made by Mr. Jaitley doesn't happen. The thing should be like this. 3 months prior to the retirement, an option should be called for from judges whether he would like to have pension or he would like to have the same facilities which he is having as a judge of the High Court or as a judge of the Supreme Court or as a Chief Justice of the High Court or a Chief Justice of India. If he opts for pension, then he is free to take that, but he is disqualified from holding any position.
For all time?
Any position.
For all
any
time?
position, yes. And if he opts for full salary and benefits, then his name should be added in panel, and whenever a post where statute provides a particular position to be filled by a High Court judge, a particular position to be filled by Chief Justice of High Court, Supreme Court judge, Chief Justice of India, the executive in consultation with the Chief Justice of India should select a man, so that there will be no accusation that judges are running after the post or their pre-retirement decisions are influenced by post-retirement benefits. As a matter of fact, in one of my meetings with the present Prime Minister also, sir, I had given that suggestion.
May I ask you, Mr. Jaitley, where are we heading? Because if we are looking at this debate, I am not seeing a middle ground emerge, A. B, fundamentally, I am seeing a hardening of positions on both sides. And as you have yourself admitted, so where is this headed? Where is this clash
This is headed in a direction where the NJAC is gone, but the debate for a better system will continue.
I now want to come to the moot point and let this be openly debated. Did the Supreme Court of India rewrite the Constitution of India? And did the Supreme Court of India undo what Ambedkar wanted as far as the role and responsibility of judges and appointing judges was concerned? We have on record here exactly what was said in the Constituent Assembly. My question to you, sir, is, and please address this clearly, or we get a response. You want to start this part of the debate, Mr. Jaitley, or you would like to start?
I start.
Mr. Rajiv Dhawan. Okay, then my question to you is the appointment, allow me to phrase it, is the appointment of judges by the collegium system a systematic deviation from the constitutionally envisaged principle that was agreed upon by the Constituent Assembly of India, from the views of Mr. Ambedkar itself? And can you please explain to the other side and to everyone today, on what basis did the judiciary of this country undo what Ambedkar wanted as far as the role and responsibility of the judiciary is concerned? Mr. Dhawan, please open the debate. Mr. Jaitley will respond.
The judiciary is always rewriting the Constitution. No, don't say like that. Try and understand it.
No, it was an admission.
No, it's not an admission. This is not a question of confession and admission. Just understand the point before you go, and ooh. Now
just an exclamation.
No, the point is, you can exclaim.
Go ahead.
You can put your finger there and go like that. See, we had a provision in Article 21 which simply said any procedure by Parliament will do to invade civil liberties. What did the judges do with it? The judges said, no, we expand the meaning of life, we expand the meaning of liberty, we expand procedure established by law to mean due process. Now, was this a rewriting of the Constitution? Yes, it was. It was.
So you read out the Constitution?
No, of course. Of course.
No, of course you wrote
the Constitution is never in a... Kindly understand this. Prophetic comment made by Justice Dwivedi in Keshwanand. The Constitution is not in a state of being, but becoming. Judges are not there to look at the Constituent Assembly debates and say, look, have we lost our liberty somewhere because of the Constituent Assembly? People like Mr. Jaitley said that this was an advance. Surely the interpretation of Article 21 is an advance. Reservations. When the judges said 50%, was it an advance? Do you want to hear how Parliament decides these questions? 77th Amendment, do you know how it was decided? Arey jaldi kariye, Rajya Sabha ruka hai. Then they went to the Rajya Sabha. And in the Rajya Sabha they said, Digvijay saying, arey aap pass kar lijiye. One chap, Mr. Murumbi, wants to speak. And he's told, Murumbi sahab boliye nahi, tera pass kar. Constitutional amendment. Now my question really is, do you think the Constitution is static? Now Mr. Jaitley doesn't oppose judicial review was not written in the Constitution.
No,
he doesn't oppose it. Basic structure was not written in the Constitution. Therefore the judges are constantly interpreting the Constitution. Don't think, and that's their job. Second, Mr. Padgaonkar's question. Mr. Padgaonkar, you are absolutely right about retirement jobs. How we work it out, whether it is the two suggestions made by Justice Lodha or not, that is the real threat to the independence of the judiciary. But where does it come from? It comes from the executive who say we will give you a job. This is the problem.
Okay.
Point number 3.
No, now I want to come to the basic point. Since this part.
You think it's a one-way process? Someone is giving you a lollipop and you're saying, no, I don't know what it is.
Why don't Mr. Das Gupta suck your own lollipop?
No, Mr. Dhawal, you saying that the whole point is it's not a one-way street. If there are laws and attraction, it's a two-way street.
Oh, yeah.
It is.
So with respect, I'd like to point out to you that the Constituent Assembly, sir, did in fact debate concurrence. It is important for you. You can't be blindsided by it to notice what Balasaheb Ambedkar said vis-a-vis concurrence of the Chief Justice of India.
Then please listen. When the matter came before the greatest commission appointed...
You had your say, Mr. Dhawan.
No. Do you know about the 14th Commission?
Sir, I know the Constituent Assembly debate of 24th May 1948.
That is your weakness.
So that's my strength on this matter. I have the facts
from
before
1950
me,
to now,
sir,
there have been a number of commissions that suggested concurrence. I was going to make a constructive point, but we want it done later.
No. Now I want this part debated from the other side.
I mean,
did the Supreme Court rewrite the Constitution?
Which you take precedence. Whether you take the Constituent Assembly as being far more important than judgments.
Ambedkar said consult the judges, but they don't necessarily have to concur. And that was the system with which we lived through the first 4 decades. 1 second. Now,
no, you didn't. That's the whole point.
Actually, that's what I said.
You think the Constitution stood still?
1959, then Home Minister Govind Vallabh once said.
I knew this was a controversial point.
Therefore, to say that all along for the last
we've had 50 years of thinking about this.
Okay, now let's get the other side on whether the... Now let's go back and look at the years 47 onward. Mr. Jaitley.
Arnab, this comes out of a mindset where, as you've seen in the debate when references to Parliament are made, I think it's a basic requirement that inter-institutional courtesies are maintained. Because Parliament debates in a particular manner, you run down the debate, I can say something about the quality of judgment, but that's not proper. So therefore, in a discussion of this kind, some inter-institutional courtesies have to be maintained. Secondly, Rajiv is right when he says that there is a power to interpret. The power to interpret is not a power to rewrite. There is a reasonable amount of flexibility available in a language where you can advance. So in Article 21, when the Constitution said that you can't take away life and liberty without procedure established by law, Justice Bhagwati said that procedure must be reasonable, just and fair. So you can expand it a little. But can any rule of interpretation make a provision read the absolute opposite of what it says? Now, when you say the opposite of what the provision says, and I'm afraid Article 124 and 217, as interpreted in the 2015 judgment, have been interpreted to state the opposite of what the Constituent Assembly had decided. Not merely the intention in Dr. Ambedkar's speech, but the language in the Constitution. So the paradox is, the Constitution says the President shall appoint, 2015 says the President shall not appoint. In consultation with the Chief Justice, it now means the Chief Justice or the Collegium alone will do it. That is how the interpretation says. And no rule of interpretation in any jurisdiction can make a provision mean the opposite of what the Constitution has said.
Mr. Lodha. I don't think, of course, it is Mr. Jaitley's view, but this is not directly opposite. Now, consultation has to be seen in the context. Now, if in the judicial administration, Chief Justice of India is head, he knows about the functioning of the judiciary, that means on its face that in the consultative process, Chief Justice of India must be given due weight. Way back, look, forget about this second judge's case, first judge's case, even before that in Shamsher Singh's case, the seventh judge bench said.
We disagree, so I'll allow a counter now.
Justice Lodha, if you see the 1942 House of Lords, Lord Atkin's dissent in the habeas corpus case which Justice Khanna followed in India, I think you go back to the last paragraph of the dissent, where the dissenting judge quoted Humpty Dumpty. And he said, when I say something, I mean what I want it to mean. Since judiciary has the last word, what you can say is to mean the opposite of what the Constitution says. So even when you wrongly decide, that's the law. So I have therefore in my blog said, the judiciary's view is final. However, it's not infallible.
Yeah, that's old saying actually. Judiciary is final not because it is right. It is right because it is final. Right. If there would have been further appeal from the Supreme Court, Supreme Court would have been as fallible as any other court.
But Mr. Jaitley, may I ask you why the executive / legislature / politicians, everyone has woken up late? Because in 1993, the executive had already accepted and embraced the system of judges appointing judges. Why is this sort of...
No, it hasn't. You see, let's be very clear. The idea of National Judicial Commission was born when you realized that the earlier system was not working effectively. And therefore, you've had at least 6 or 7 parliamentary committees. You've had specialized commissions. Each one of them, without an exception, recommended in the direction of the National Judicial Commission. Now, if you look up the UPA bill and you look up the NDA bill, on composition both are identical. If you look up the left front, the NDA or the UPA and look at their manifestos, they all say the same thing, virtually. Political expediency, now they may take different positions. But effectively this debate, and let me tell you, many of the eminent senior counsels who argued against this constitution amendment, if you pick up their own autobiographies and their own speeches, they effectively have been saying the existing system has failed and therefore we must look for a new one. Whether it's a perfect commission or an imperfect commission can be a matter of debate. But the system needs a change. It cannot exclusively be, as I said, a Gymkhana Club membership where members decide who should be the next member. This is how the existing system is working.
And Arnab, my question is, why hasn't the dissent of Justice Shamleshwar been taken into account? What do you find wrong with it? I think the judges very well pointed out as to how important it is that judges should appoint, but not exclusivity. That's the dissent. No one has talked about it.
Well, that's a dissenting judgment. We can go into the
details. What's wrong with that?
It's a minority
What's wrong with that judgment?
Yeah, minority judgment. We can go into that later. You want to respond to that? No, you had a counter. You had a counter to him because I want to go to the issue of what best represents the interests of the people.
I was a counsel in this case. I'll tell you what makes things a little difficult. Does Mr. Jaitley really believe we have a Humpty Dumpty judiciary? We don't. Lord Atkin's dissent was about the majority in that case. We don't have a Humpty Dumpty judiciary. We are proud of this institution because it does things to balance what the executive and parliament does. Secondly, it is not a tyrannical judiciary. And thirdly, the third phrase, which obviously catches the laughter of the House. Is there a judicial gymkhana club? You'd be surprised. It may exist with politicians, but no. The central question is, when you talk of accountability and you use Humpty Dumpty phrases, is this. Do you believe our judges have discipline? A large number of them are good, some are bad. I believe, and that's the only reason why I practice in that institution, is I believe they have discipline, they have given something to this country, they are not Humpty Dumptys, and they don't belong to a gymkhana.
Yeah, but why do you want to be so opaque?
No,
but why do you want to be so opaque, sir? My question
yes,
is
now I
have a small question, Rajiv. Would you say that the habeas corpus judgment was a Humpty Dumpty judgment?
It was terrible.
Yeah.
Of course it was terrible.
It was terrible. It was terrible, and it was the idea of the committed judiciary, which I remember you supported at one time.
A committed judiciary to social justice, I support.
Yes, you supported the idea of committed judiciary.
But for what? You want to make debating points, make them, but don't smile.
You are an accomplished debater.
Don't smile after that.
You
I don't
are
like
an
your smile.
accomplished debater.
I'll tell you one thing.
Rajiv Dhawan.
I want to say one thing.
We are on a critical point. No, listen to me. Rajiv Dhawan, we are closing in on the final part of the debate. Rajiv Dhawan, 1 second. I will now come in, Rajiv Dhawan. Please, 1 second.
Say
so you can't run away with the debate.
Before you respond, just give me one.
So I'm not responding. You're responding.
All right. You know, this debate is actually going nowhere. It is not a constructive debate.
Mr. Dhawan,
it's not a constructive
let the audience
debate.
decide on it.
If you were the Chief Justice today, would you agree and appreciate if the recommendations made and the proceedings were all subject to RTI?
There are two options open. Either to make it public after appointments are made, or before appointments are made.
Mr. Jaitley, equally, would you bring political parties under the RTI? I'm on the final point. Since directly or indirectly, consciously or unconsciously, deliberately or without any deliberation, your basic thrust is we are keeping ourselves and our interests and our power stronger to us, with us, and we don't want to give it up, not because we think we are infallible. You say it's not because we think we are infallible, but because we think it best serves the people of India. Is this your basic argument? So having said that, I want the concluding part to be on what serves the people of India. Justice Lodha, what best serves the Indian public? One question to you, and then we'll respond with the last 15 minutes of the debate. What best serves the people of India? That they know those who will be dispensing justice to them are appointed, or that the process remains, pardon my saying so, some kind of an opaque state secret?
No, that is true. That is true, that the system is opaque, secretive. And as Chief Justice of India, I found basically three faults with the system. One, lack of transparency. That is the major fault which needs to be rectified. I'll come to the solution little later. Second fault, which I found, was lack of availability of an expert body. You call it evaluating body, advisory council, or standing committee to help the collegium. And three, very important, executives' indifferent role in this participative process. Because I find that executive can play a very crucial and important role in the appointment of judges, even though primacy rests with the Collegium or Chief Justice of India. Now, to bring in transparency, I tell you, transparency, first, standards or norms of appointment, they must be known to all. Then, all processes of the appointment must be transparent. Now, there can't be secretive.
But there is a veil of secrecy.
I'm telling you, one of the law ministers, he named Mr. Bharadwaj. I know his remarks. When a name from Rajasthan High Court would go to the law ministry, he would say before it is received by the law ministry, he receives 100 complaints regarding that candidate. Now this mindset that if name is made public or known to everybody, lots of complaints will flow in, cannot perhaps be allowed to have any place in today's world.
Sir, but my question is unanswered. Since you say it serves the people of India, India today wants transparency, openness. We want to have an idea with clarity. And I'm sorry, sir, you cannot have a situation where the Indian judiciary, for all its rights, fends off with all its strength every single democratic attempt to lift that veil of secrecy. You are fully aware, sir, of how the judiciary has pushed back against the Central Information Commission. The CIC has confronted the Supreme Court about judges' appointments. The Supreme Court has fended that away. And hence I'm asking you today, if you want to be all-powerful, and I think it's a major admission on your part that you cannot be secretive about the process. Response from the other side, what best serves the people of India in the context of transparency? Arun Jaitley, a judiciary that remains above any conflict of interest with no strings attached, is that best? Or one that owes its appointment to the executive and then is expected to remain wholly neutral in its deliberations?
I think, notwithstanding Rajiv Dhawan's efforts to misinterpret my argument, of course we don't need a Humpty Dumpty judiciary. It's nobody's case that we have it. You need an independent judiciary. You need a very competent judiciary. You need a judiciary which has high levels of credibility. And therefore, a judiciary, which Justice Lodha rightly mentions, which is appointed by a participatory role of various institutions, I think will be a fair judiciary. Now, a judiciary where participatory role of other institutions is eliminated, the process remains secret. At least the appointment process will never have credibility. And I think the existing system is full of flaws. The men who conceived the existing system, Justice J.S. Verma, and we all know it, regretted having conceived it. He said, this is not what I intended, and the way it's working, it needs to be changed, and therefore it needs to be reformed. That's what suits the interest of India. We need an independent judiciary, but we also need a credible judiciary.
May I answer?
Go ahead.
See, what is good for the people of India, and here Arun and I are at idem. We need a very strong, very powerful judiciary. Because in India, the overrun of power and corruption is so great that if you don't have an independent judiciary, then something will go wrong. Now, how do you get it? That is why I said this debate is actually going nowhere, and it's not for the audience to decide, it's for us to be satisfied by their arguments and ours with them. One of the critical problems that has happened from post-emergency to 1993 was law minister interference. That is the biggest. I mentioned the two names. That has been what has put the judiciary off the back foot. And Arun, if he was being honest to himself, would admit that. That is a fear that the judiciary has had. But your question has a follow-up in this, Arnab. And the question is, which would now be the best system? Unfortunately, the NJAC was a khichdi. It was a badly formulated khichdi. So we come back to the collegium. The answer to Swapan's question is, yes, it will go back to the 9-judge bench. Therefore, I think the positive step to be taken is forget about the NJAC for the moment. It will require a huge majority to deal with it. Therefore, what do we do with the present collegium? On the 3rd of November, that very bench has invited the lawyers to indicate how can we get transparency and accountability. Now, I'm conscious of the fact that there is opacity in this. But I'm also conscious of the fact that judges are under pressure to lose this opacity. And if this discussion is going to go anywhere in a constructive sort of way, that is what we should be talking about.
So what basically, your argument is that I have made the pudding, it's only about how much sugar needs to be put in.
No.
You've decided what kind of pudding it's going to be.
At present, you have a faith, one second.
No, one second. Now
at present, you have a faith accompli.
So I'm trying to find...
NJAC is gone. What do we do in the meanwhile?
The sense I get,
Justice Lodha, in that case, would it not have been far more prudent for the Supreme Court to have written down the NJAC Act and actually, in that sense, prevent what is emerging at present, a seemingly direct confrontation between the executive and the judiciary?
Absolutely.
This was one of the options available, but if you read the judgment, the argument of Attorney General was emphatic that you test the validity on the touchstone whether it hits the basic structure or not. You cannot alter about the eminent persons. You cannot alter the inclusion of law minister. That is not what the court can do. Now, having regard to that argument, the court's option was foreclosed. The court had no option at all.
I therefore, as I am...
And therefore, I feel the time has come till, of course, the parliament take its call. That is always available. That in the light of the law that has been laid down, you amend the constitution. No, that is not taken away. Surely not. The alternate system is still available. That has to meet the twin test that you don't take away the primacy of judiciary in appointment of judges.
But I thought...
you don't take away the independence.
Get a better NJAC.
Mr. Jaitley,
yeah. We need a better NJAC.
But on a lighter vein, I think the next set of reform, which Dr. Dhawan mentioned on the 3rd of November, is also to take place outside Parliament. Now the function of the Constituent Assembly is to be performed elsewhere now.
Why use the Constituent Assembly? What has it got to do with this?
May I then ask you, Mr. Jaitley, and Mr. Padgaonkar, you're listening, may I ask you, Mr. Jaitley, where are we heading? Because if we are looking at this debate, I am not seeing a middle ground emerge, A. B, fundamentally, I am seeing a hardening of positions on both sides. And as you have yourself admitted, where is this headed? Where is this clash?
This is headed in a direction where the NJAC is gone, but the debate for a better system will continue.
Yes. And where will that debate happen, Mr. Jaitley?
It's a process.
I think it can also happen in Parliament. It happens at 9 o'clock every evening.
Well, at this point, Mr. Padgaonkar and Swapan Dasgupta, I want to get you into this. I am witnessing here, very clearly before me, a distrust on both sides.
No.
There is one side which feels hurt, and both sides feel that the other side is trying to usurp their own positions. Where is this argument therefore headed? In the next 2 or 3 months, let me start with you, Mr. Padgaonkar. Are you seeing this debate, which we've begun today with the national debate, actually widen, get more polarized? And where do you think, where do you think it needs to be actually carried out forward? I mean, I'm seeing,
consult Humpty Dumpty.
As a matter of fact.
Mr. Justice Lodha, they're not agreeing with you, and neither are
No, they may not.
We're not.
They may not. Look,
but they have a right
I don't think there is a dispute on that.
Yeah.
The Supreme Court, rightly or wrongly, has decided that judgment has to be complied with. The judgments will be complied with, and therefore the system will remain. But a debate for a better system will always continue.
Absolutely.
And this should be taken as an opportunity.
And let that better system be
executive in suggesting. In suggesting to the court an institutional design which brings in transparency, which brings in fairness. So that institutional
Justice
design.
Lodha, if you were the Chief Justice today, would you agree and appreciate if the recommendations made and the proceedings were all subject to RTI?
RTI or no, but surely, there are two options open. Either to make it public after appointments are made, or before appointments are made. The better option is, having regard to the Indian psyche, that once the appointments are made, the entire record is brought in public domain. Now, whether through RTI or any other means is anybody's.
But Mr. Jaitley, equally, would you bring political parties under the RTI?
Are you trying to work out a deal?
So one thing I've never been good at is trying to work out a compromise.
Arnab, I think that question is before the Supreme Court.
Well, you know, I have so many questions on both. I've enjoyed this. Dilip Padgaonkar, please. Your view, sir, please.
You know, we've had a lot of talk about basic structure, separation of powers, checks and balances, etc. I think I'd like to end by saying that for me, honestly, what is basic is the preamble of the Constitution. It's the preamble of the Constitution that gives you the ethos of the Constitution, and it'll give you certain indications of the kind of structures that have to be put in place in order to realize the ethos or the goals of the Constitution. This is one. Secondly, we've now reached, and this debate has told me, that there is at the moment no common ground between those who were in favor of the NJAC and those who want a revamped collegium, so to speak. I believe that the only via media at the moment is to think of a mechanism, a body, which will be much more inclusive in deciding or at least vetting applications to the judiciary, making them public, the process to be made public from the word go and not after a decision has been taken. Let people, because there are a lot of people across the country who may have opinions, but for this you need some kind of a body which has enough manpower to be able to vet all this. And then as far as the primacy of the judiciary is concerned, I think if you've got a real solid body with evidence, with data available, and that is made available to the judges of the Supreme Court, then the judges will again have to make public the reasons why they refuse a particular nomination. And the same thing I think will hold good for the government. The government ought at every stage to say why they reject a certain number of names that have been proposed. So the key really is transparency and accountability, since it cannot be done exclusively within the executive or exclusively within the judiciary. I would therefore suggest that we come up with this possible third way.
You see, a constitution is not merely something for the judges and for the experts. It's something which applies to every one of us all. Every citizen of India is affected by the Constitution. Therefore, I find it a little disturbing when we are told that what you read in the Constitution in language which I think is reasonably erudite and simple is not what it means. That being is different from becoming. That these are issues which have to be left to loftier minds alone to judge. To my mind, that's it's a takeaway, and it worries me a lot. Okay. I think there is a small anecdote I want to say. You see, the global competitiveness report which the World Economic Forum does, they do one of the how the politicians are recognized and what is the extent of which the judiciary, the independence of judiciary is there. India's political rank, actually, from the Indian politicians ranked 97 out of 144 in 2011 and 12, and in 2015 it had risen to 31. But judiciary, however, the independence of the judiciary, where it was 51 out of 144 in 2011-12, it had slipped to 64. Now, does that tell us a tale which we are not aware of? I don't know. Maybe that's an interesting footnote.
I will conclude at this point. Yeah. See, for me, what is very interesting as a takeaway is, I found that both sides agreed on a few critical points. There was mutual self-respect in large parts of the debate. I think I heard one side say no confrontation. I would welcome that. I think that is the spirit of a good debate. And there was, from both sides, openness to have further debate and a further discussion. And I think that process of intellectual osmosis is something that will be appreciated. But most importantly, and I think Swapanda, Mr. Padgaonkar, everyone will agree with me, what makes our democracy truly great is that you can have the legislature and the judiciary and the most distinguished members of both before an open audience like this in the national capital and have a debate like this, and the media conducts a debate like this. So for that, I'm grateful to each one of you in the audience. I'm grateful to you, Arun Jaitley, Soli Sorabji, to Justice Lodha and Rajiv Dhawan, and of course Swapanda and Dilip Padgaonkar.
And your moment of redemption.
And my moment of redemption. since I think I have spoken the least in this debate. I thank you very much. Thank you very much for this national debate.